Do you have a loved one who is having trouble handling their financial affairs or is struggling to manage their food and healthcare? If so, you might want to consider whether establishing a conservatorship would be appropriate. Here's an easy guide to understanding conservatorships, the process, working with an attorney, and the basic costs. Plus, we'll cover some variations on conservatorships, including guardianship, advanced healthcare directives, and LPS conservatorships. A conservatorship is when a court appoints a responsible person or group to care for another person, specifically to make responsible financial decisions or healthcare management. The person appointed is referred to as the conservator, and the person being cared for is called the conservatee. A conservatorship is created to help care for a person who can no longer make appropriate financial or healthcare decisions, possibly due to illness, incapacity, or disability. Typically, when an elder or disabled loved one is planning for their future and considering their own possible physical or mental incapacity, they may give a durable power of attorney to a responsible adult, often their child, who is then authorized to make a wide array of financial decisions for them, for their benefit. The same can be done with regard to healthcare with an advanced healthcare directive. However, if a loved one becomes incapacitated without a durable power of attorney or advanced healthcare directive, a conservatorship can be established by the court. The court will name a responsible adult the conservator, enabling them to make financial and healthcare decisions for the conservatee. Most decisions of daily life can be made for the conservatee by the conservator, including healthcare costs, purchasing food, clothing, home ownership or rental, monthly bills, financial investment decisions, transportation and travel costs, caregivers, and caregiver costs. A conservator is a court-appointed person or group who operates as a fiduciary to the conservatee and must put the conservatee's needs ahead of their own. Their duties may include managing the conservatee's living situation, caring for or managing care of the conservatee, working with the court to establish a care management plan for the conservatee, reporting to the court regarding the conservatee's status. A conservatorship creates certainty as to who has authority to act on behalf of the conservatee. Often, a loved one can be pushed and pulled by family members, friends, or even strangers. Basically, conservatorship answers the question of who is in charge. A conservatorship protects a conservatee from being taken advantage of by hangers-on by removing their ability to handle their financial matters. A conservatorship is often the only option for a loved one who already cannot handle their own affairs because they're already incapacitated. If they're in a coma or have had a debilitating stroke, a conservatorship can be established to help ensure responsible financial and healthcare decisions are being made for them. One downside is the fact that conservatorships are a matter of public record. What does that mean? If the conservatee is a public figure, or if they're just sensitive to privacy issues, what already is a sensitive subject, removing someone's decision-making ability, may make a conservatorship less desirable for that person. Conservatorships are expensive in relation to the cost of a power of attorney or advanced healthcare directive. An uncontested conservatorship can easily cost $10,000, and multiples of that if the conservatorship is resisted by the proposed conservatee or if several persons seek to be appointed and the matter needs to be litigated. Conservatorships remain under court supervision, which require annual accountings and reports to the court, which take time and cost money. We consider the best alternative to be planning ahead in the form of a durable power of attorney and advanced healthcare directive. If a loved one gives a responsible adult, again, often their child, a durable power of attorney over their financial and an advanced healthcare directive over their healthcare, then a conservatorship may be avoided. The caveat is that a durable power of attorney and advanced healthcare directive must be established while your loved one is still of sound mind and body. If they become incapacitated without them, then a court-appointed conservatorship is likely the only way that you'll be able to manage their affairs. An LPS conservatorship is a special type of conservatorship that applies in limited circumstances, such as where a loved one suffers from disability as a result of a serious mental illness, like schizophrenia. LPS conservatorships are not intended for adults with developmental disabilities nor drug or alcohol addictions. LPS conservatorships cannot be initiated by private citizens. Only the public guardian can initiate an LPS conservatorship. Conservatorships are complex, meaning that you'll be best served by consulting with a probate attorney familiar with the intricacies involved in establishing conservatorships. Establishing a conservatorship in Los Angeles, or any state or county, is a time-consuming process that can take several months, or longer. Here's a brief overview of the steps. File a petition for conservatorship with the Superior Court. You'll get a court date, scheduling your first hearing. You'll notify the conservatee and the conservatee's relatives of that court date. The court will appoint a court-appointed counsel to go and visit with the proposed conservatee. The court will also send out an investigator to meet with the conservatee. Both of these people will try and determine what is in the conservatee's best interest and what the conservatee wants. You'll then attend that initial court hearing at the Los Angeles Superior Court. If the conservatorship is granted, letters of conservatorship will be issued. The conservator must submit a care plan to be approved by the court. And finally, the conservator must report annually on the status of the conservatee and their affairs. If you would like to establish a conservatorship on your own, there's a link to a petition for conservatorship form in this video's description and blog article. If you'd like help, contact RMO lawyers anytime. Court forms typically involve filing fees. Attorney's fees are based on individual attorney costs, conservatorship complexity, and any associated litigation. It often helps to work with a probate attorney near you. However, it's more important to retain a probate attorney who's familiar with the county probate court in the proposed conservatee's county of residence. For example, if the conservatee resides in Los Angeles, you should consider retaining a probate attorney familiar with the Los Angeles Superior Probate Court. At RMO Lawyers, we protect people like you and your loved ones every day, and we're happy to offer you a free consultation. Just email us at hello@rmolawyers.com. Thanks for watching.